Good morning from Southampton, and good afternoon, good evening, depending on where it is in the world that you're joining from us from for this webinar. I'm Emily Reid. I'm Professor of International Economic Law and Sustainable Development here in Southampton Law School, but I'm also the Director of Internationalisation within the Law School, which means that I kind of have oversight over all of our international activities, whether they're related to education, which you might be more interested in at this particular point, but also relating to our research activities with international partners. And so today I'm chairing this session. So the first thing I'm going to do is give you a little outline as to the format, what we're going to be covering in the session, and then I will hand over to my colleagues. All right, so the first thing that we will do is we will have a mini lecture, a taster lecture from Dr. Alexandros Ntovas, who is the Director of the Maritime Law Institute at the University of Southampton. And he will be giving you a mini lecture on place of refuge in ships in distress revisited, which is clearly very timely and of enormous contemporary significance. Following his lecture, we will then have a brief talk from Professor Uta Cole, who's the Director of the LLM programs in the law school. And then following the talk from Professor Cole, there will be a question and answer session. And during that session, you can ask any questions either relating to the law programs, the PGT program, the Maritime Law program, which you are interested in, or you can also ask any questions that you might have relating to Dr. Ntovas's lecture. And after that, that will be the end of the session. All right, so what I will do at this point is hand you over to my colleague, Dr. Alexandros Ntovas, the Director of the Institute of Maritime Law.
Good morning, all. It's a great pleasure to have the opportunity to give a lecture on a topic that it's quite fascinating, especially this period of time. And it gave me also the opportunity to reflect back on what I had been teaching all this year in maritime law, but also to get reminded of those things that most of us teaching and practicing maritime law we might have forgotten. So with any further ado, I will proceed with my slide presentation. I will try to confine my presentation into 20 minutes or so. The title is COVID-19, which is a term that we are extremely affiliated with that nowadays. And I would like to see what is the effect in relation to maritime law by focusing on the place of refuge and ships in distress. Now, a good opening slide, quite maritime in its nature, but above all quite British in its origination, is an oil paint on canvas made by Peter Monamy, who is one of the first born English painters to have specialized in maritime themes. As you can see, the title of that painting is Ships in Distress in a Storm. For those that you have a maritime, slightly relevant to maritime law background, you will be immediately easy to pick up the legal terms, ships in distress. And although the title of the painting dates back to the 17th century, which is a very important century for our discussion today, is also very important for the law. So what actually in distress means for ships? So I will leave that question for the time being, and I will go back shortly to that. Now, a very close theme But this time, you know, this slide depicts something real. It's the incident of Erika and Prestige, two tankers which suffered pretty much the same fate in the very same place under same circumstances with 3 years apart. Here you can see Erika sinking off the coast of Biscay, and in the same place, as you can see, 3 years later, Prestige suffered the same fate, sinking. So what was the legal common connection between these two, and what is the nexus with the discussion today? Both of these ships had run into heavy weather, into storm, and suffered some structural inconsistencies in their hulls, which required that they should go into a port of safety, into a place where they could have repairs and sheltered by the weather. Nevertheless, the states of the region firmly refused access to these ships on account of an environmental threat. Both of these ships were very old. They were carrying a lot of cargo. In relation to Prestige, the cargo was over 70,000 tons, and therefore the states in the region, namely Portugal, Spain, France, pushed away that vessel, both of these vessels into the sea. And the outcome, as you saw, was actually, after wandering around for a couple of weeks, the condition of these vessels deteriorated and eventually sank, leading to extensive environmental pollution. So how that now relates to COVID? As we know, and this is the evidence that are being sourced through the World Health Organization, COVID is a pneumonia-based disease that originated in Wuhan, China, and in late January was proclaimed to be a public health emergency of international concern, receiving the formal name as we use it nowadays, COVID-19. Let's now put into the discussion the place of refuge and COVID together. Before we do that, I would like to say a few things about the history of contagious and infectious diseases. COVID, like many others that we know, they might sound known to us, but for good reasons we have forgotten. It's one of the pandemics that have shaped our history, and especially the maritime law history that we have forgotten, and I would like today to bring into light again. So COVID-19, in terms of contagious and infection disease, is not something new for maritime law, but it certainly was forgotten for more than 5 centuries. We have, since the 13th century in particular, we have other pandemics like smallpox, influenza, tuberculosis, rabies, HIV, which is within the list of infectious pandemics, but not easily contagious pandemics, cholera, yellow fever, that I will have a slide in relation to that, malaria, which is one of the traditional maritime diseases on board ships, Ebola. Very recently, in 2015, we had the endemic in many states in Africa, Ebola affecting shipping, and of course, one of the most fearsome but long forgotten, and thank God for that, the plague. The plague refers to the spread of the bubonic and septicemic plague that arrived in Europe, and you can see the maritime route that facilitated the spread of the disease from the Orient. And at the time, it was the 13th century, the Genoa, it was the major port city in the known world. So the spread of the plague came on board Genovese ships. First time appeared in the Geneva port, and then it was spread deeper into Europe, arriving also into England around 1348. Now, we could say that at the time, ships and the maritime commercial trading areas, routes and areas facilitated the spread of the disease, as happened today with mainly the airliners and traveling by air. Now, this is taken from the New York Times in 1883, which covers a second very important pandemic, that of the yellow fever. And you can see that the drawing there depicts a British ship. You can see the Union Jack flag of the ship to approach the New York coast. And you can see the Board of Health, which was a public agency which was discharged and responsible to fight off pandemics and undertake safety and policy measures. You can see also some small details that I managed to decode. First, the fez borne by the skeleton, which is actually a connotation of the yellow fever coming and originating from the east. And also you can see the bottles, which are turned like cannons towards the British ship. And the boat and the bottles, what they contained was actually carbolic acid, which is, you know, the scientific name for what we all use today, like this small bottle of disinfectant. Now, the Board of Health at the New York was responsible, as I said, to take preventive measures. And this was for the first time happened back in Genoa in the 13th century, which actually was the very first maritime port to establish the practice of what is called now quarantine. And we have been using, unfortunately, this term quite extensively this period of time to mention that we are locked down in a state of quarantine. But quarantine, it's a Genovese dialect which actually describes a period of seclusion. And in a Genovese dialect, it reads as 40 giorni, which means the big 40 days. And this practice was put in place in order to make sure that a ship, having been infected with a contagious disease, will not be a threat to the city and to the people of the city and to the extension to the normal life of that state. So what is nowadays the immediate effect of the current pandemic that we are facing in maritime law? It's quite extensive. It has touched upon all important maritime law issues. Charter parties, the contracts of hire of vessel and cargo. It has, in a number of cases, put off hire vessels in means that they cannot trade. That has resulted in demurrage and lay times. The fees that are being paid as extra because the vessel is held back. Also, it has raised issues of safe port and safe berth in relation to warranties, whether or not the ship is being sent in a safe port if that state is being infected with a contagious disease, or the vessel can actually depart from that place to go elsewhere. Important effects we have also in relation to the goods that are being carried. Excuse me. And especially that it's very important when the cargo is perishable, because on the top of the off-hire complications, we might have the devaluation and the total loss of the cargo. For example, you can imagine a vessel carrying bananas, which are perishable cargo, to be in quarantine for 40 days without being able to discharge its cargo or to take new cargo from a port. These are being covered mostly by insurance, although this might refer back to old insurance covers, which might be now disused, but nowadays came to the forefront once again. However, to my opinion, the most important issue, which underlines all of the above, it's something that is not very easily noticed by the maritime lawyers and the general public, and that is the freedom of navigation and the laws and the practices that allow a ship to navigate freely. And most importantly, a part of that principle that has to do with the freedom to access a port. And this can break down in 4 significant aspects, but I will only cover in more depth just one. The first one is the deviation. It needs to go to a specific safe port where probably it will not be able to discharge its cargo to the designated or owner of the charter party. It has to do with the seaworthiness, because if the crew is in a dire health condition, then the seaworthiness comes into question for the vessel. If the vessel does not reach into port in time, it might have its certificates expired, not being renewed by port authorities. Even if it goes into a port in a place of quarantine, we do have important issues that affect the crew of the vessel, the human element, regarding the embarkation of new crew or other people, or disembarkation of the crew. Also, it will need to undergo very important inspection and vetting processes in order to make sure that the vessel does not pose any further threats to the port and the coastal state. And for a very narrow but yet very important occasion, when we have passenger vessels, these cargo, these sui generis of very special nature cargo, it becomes really important, like cruise ships. And I am sure you might have glimpsed from the news the headlines regarding the Diamond Princess that was operated by the Princess Cruise, one of the most known cruise operators, and that happened on late January and beginning of February. Just to give you an idea, the Diamond Princess has, together with the crew and the passengers, a total capacity of 3,700 people on board. So it's actually a very small town. In late January, it had departed as part of the cruise from Hong Kong, and it was en route to Yokohama, Japan. Nevertheless, at the time, it was when we became aware through the health organization that we are in front of a pandemic. So en route to Japan, it was notified, became known to the captain that one of the passengers that had disembarked in Hong Kong, the previous destination, it was tested positive with coronavirus, which of course made very likely that the whole vessel had turned into a breeding ground for that infectious disease, and it was close to 4,000 people. Now, the vessel, it was en route to Yokohama, Japan, and it requested to disembark, to access the port and disembark as normal. But nevertheless, Japanese authorities refused entry to the vessel, which made a very important situation, which turned the vessel into a very important health and safety risk. So what happened with these people that need to get medical attention? Now, this controversy, of course, surfaced into the news, and this is the one part of the headlines. And eventually, after international political pressure, the vessel was admitted in the port of Yokohama. But let me carry on with my discussion, and I will go back to that incident in order to be able better to evaluate what happened there. So access to ports, although it's a very normal and common tradition nowadays, it's also something that has not been properly recorded into our laws. So it has a very strong but very volatile and uncertain in that way customary basis, and it's better in the geese of law seen as a long maritime tradition. The treaty practice in the 10th, 11th centuries, the yearly practice does not sanction that as a commitment to receive any vessel, and more or less even, you know, a vessel that is in distress, but is being as a mutual allowance between states to treat these vessels with all kindness and humanity, and to provide all friendly protection. And this is actually the legal language. We don't know what actually means kindness and humanity, but we can, you know, understand various forms that these can be demonstrated. Even today, the contemporary practice in a number of multilateral treaties does not give free access to any vessels, including vessels in distress, but there is a balance between rights and freedoms of the coastal states and the rights and freedoms of the ships in terms of navigation. In a very important treaty, UNCLOS, we do have even a very strict qualification of this balance of the respective rights. Now, let me go back into the slide with the Diamond Princess. Why the Japanese denied entry into the port? At the time, and that was on the 3rd of February, the passenger vessel, the cruise ship, had been tested through medical kits that had been dispensed by the Japanese authorities in the middle of the sea, with 542 incidents. So on board the ship, we had almost 600 confirmed cases. At the same time, in Japan, which is a very densely populated place, the tested positively occasions were only 72. So you can see the balance of interest. You had a huge cruise ship having almost 6-7 times bigger numbers than Japan itself, and therefore Japan was afraid that having that influx of COVID-19 occasions will put in danger the public health of that state. Going back, and this is very close to my end for to the end of my presentation, I have referred so far to distress, and this goes back to my first slide. So what is distress? It's a legal term, and it's quite affiliated but very much confused, especially from the commercial law side, with force majeure. And force majeure, it's another Latin expression which dates back to this kind of long maritime history. Force majeure, it's an act that is being brought about by an irresistible force on an unforeseen event. And this leads to a person or an entity to be impossible to perform an obligation due to that event. Distress, on the other hand, it's something quite different. Distress, it relates to start with a force majeure event, but distress covers exclusively only situations where the human life is in peril. So, for example, like the scenario that we saw with the cruise ship. Also, a very distinctive characteristic with the force of majeure is that in the force of majeure, confronting an irresistible force, there is no scope for action to be voluntary. So we act in involuntary way. While in distress, we act consciously. We know that we cannot perform an obligation in order to do something else, and that something else is to save life. For example, that was the legal underlying argument for the cruise ship to exert pressure into the Japanese authorities to get access eventually into the Yokohama port. Now, my very last slide tries to bring all together this and ask whether or not we need to revisit the doctrine. And what is the doctrine? The doctrine is that nowadays we have been reminded that they can be very important situations for place of refuge that go beyond environmental considerations like in Erica and in Prestige. And these considerations have to do with human life, something that had not raised any concern for 6 or 7 centuries now, but now by looking at the incident with the cruise ships, it became possibly a probability now and in the future. So we need to go back and revisit a number of important conventions which have not been drafted with that kind of situation in mind. The Safety of Life at Sea, the 1974 convention with the International Safety and Management Code, which aims to deal with these kind of situations. The Convention on the Facilitation of Maritime Traffic regarding entry of vessels into foreign ports. And you can see that this is as well a very old convention, 1965. We did have amendments in 2005, but this did not cover incidents of that scale. And now we do have as well a political framework in order to be able to set off that legal process towards something more concrete. And in the space of 4 months, from January up to May, the IMO, the International Maritime Organization, issued more than 15 extensive circulars, which of course do not have any legal bindingness, but offered as a consultancy to states to deal with this matter. So we do have a lot of things to cover ahead of us and in terms of law. And I hope that this at least gave you the very broad picture about the COVID situation, the maritime law, but in terms of navigation, which is the angle that I chose to approach that matter, something that has not come quite clearly yet in the news. But it's up for us, for the maritime lawyers, to go into more depth, looking back at the history, but also ahead to the future in order to shape new law. Thank you.
Many thanks, Alexandros. That was a fascinating lecture. I had not actually connected the pandemic with maritime law, but now that you've spoken about it, I don't know why I didn't. I also thought it was very interesting of how we are going back 600 years to deal with the pandemic and the traditional maritime law principles. So very interesting insights, and it goes to show that actually maritime law is alive and kicking, both in the world and in our law school. Okay, my name is Uta Kohl. I'm a professor of commercial law and the director of postgraduate programs in the law school. And I'm going to talk a little bit about the LLM program. There is in particular the LLM Maritime Law program, but altogether about the structure of the program and what we have to offer and what you can expect. There will be plenty of time for you to ask questions later on, so make a note of questions as whilst I speak, if there's anything I forget to cover, or which additional information you would like to know. Now, I'm trying to move the slides on, but okay, I need to go back. How do I go back? Oh, Daisy, could you take me back to them? Sorry, I seem to have gone way ahead with these slides. Oh yes, here we go. So Southampton Law School, I thought, I was going to start with the first slide, which shows that Southampton Law School is, and you probably know this, in the top 20 law schools according to the Times and the Sunday Times Good University Guides of 2020. We are, of course, also one of the leading schools to offer maritime law. And the reason why I'm starting with that is to really say that this really underwrites much of what we do in the law school. We are very ambitious and committed, both in terms of teaching and giving students the best experience they can possibly have to make them highly employable later on. And in terms, of course, and this is not disconnected at all, in terms of our research, the quality of our research, and so on. So especially at the postgraduate level, our research is very much, our teaching is very much research-led. So you will be taught by colleagues whose interest lies in the very areas they will be teaching about, with Alexandros as the director of the Maritime Law Institute, of course, taking the lead. Moving on, there is a picture of the law school. That's the entrance of the law school we are building for. But moving on, Southampton Law School. As I said before, here we are. This is about the staff. We are taking our research very seriously. We are committed to, being at the cutting edge of our various areas of expertise, participating in national and international discussions on these topics, and hopefully you will be benefiting from that, in that the lectures will be reflecting on staff research interest and whatever they will be researching at the latest moment. Now, why take an LLM? Obviously, you are here already. You've applied. You've been made an offer, so you know already why you want to take an LLM. From our perspective, the reasons, what are good reasons to take an LLM, is, of course, first and foremost, that you will get very highly specialized expertise in an area which you either are interested in or hope to build a career, or ideally both of which. We also aim to give you or improve a number of skills. So Writing skills is very clearly one of the key skills you will be taking away from your degree, but there will also be plenty of opportunity for you to participate in discussions, and so your oral communication skills will be improved. You will be working in teams at various stages, and so these skills are probably from an employment perspective at least as important as the specialized expertise you will be getting. A lot of our LLM students in maritime law or in the other degrees come from a non-common law background. So if you don't be worried about it. We know this, we take this into account. Our teaching right at the beginning gives everybody an opportunity in a 1-week sort of short course to basically get the foundations of how to do common law. For those who come from a common law background, that will be a very good consolidation, and then of course the entire course will one way or another involve common law principles, and in conjunction of course with much international law. So there's an overlap here between the common law and the international law, and I think especially, I suppose, in the maritime context, quite a lot of the law comes from the English common law. I'm thinking here particularly about marine insurance, but it's overlaid now with international law principles. So you will get a very interesting mix of different legal areas, and your skill set should improve significantly. The next point that might seem less important, but I think as from an experiential point of view, it's very important. Our postgraduate cohort is extremely international. Actually, the British students are probably the minority. We have students from all corners of the world, which makes for a very, very interesting mix of experiences, cultural backgrounds, and so on. And I think that really is actually one of the sort of key characteristics of the court that will shape your experience and probably will make for very good memories. Last but not least, and I will come to that in a more specific way, you will have the opportunity to research in a specific area, and that will be an area of your choice when it comes to the dissertation. Now, I will talk about that in a second. Okay, now here we're coming to the more nitty-gritty of our LLM, and that's the overall structure. And that structure applies really across the board of our LLMs, and so it's applicable to maritime law much as it is applicable to commercial and corporate law. The LLM consists 2/3 of the taught part and 1/3 of the dissertation. The taught part starts at the end of September and takes you right to the end of May with the exams. The taught part will consist of you doing per semester 4 modules. Each module will have 2 contact hours per week. So you will have 8 contact hours of classes, or 8 hours of classes each week, which may at this point not seem a lot, but from experience we know that our students find this more than enough, because actually a lot of these classes will require preparation from you. So this is not a time when you sort of can sit back and relax and just turn up to your classes. You will have to do reading beforehand. Sometimes you will be getting problem questions, which you then discuss in the seminar. So there will be plenty of work. And so you, I think the sort of a core feature of our LLMs, or a core ambition we have, is that it is a rigorous LLM, and this of course means that we will teach you in a rigorous way, but you will also have to do a lot of studying towards the degree and towards getting a good degree. Now, that brings me to the dissertation. The dissertation is worth a third of the overall degree. It's a fairly lengthy essay of 12 to 15,000 words. Quite a lot of students actually do not have experience of writing long essays, and we are very conscious of that. So we will be supporting you right from the moment go. You will be getting classes both on research methods and on writing skills. You will also have plenty of opportunity during the year, during the taught part, to write shorter essays in various forms. So don't be daunted. Our students cope with it. It is a challenging experience, but in the end, it will also be a very good experience. And so far that you will become, it will give you an opportunity to become an expert in a particular area in a very supportive environment. And that is not often, you will not have that opportunity very often in your life. So I always encourage my students to make the most of it. These are our three LLMs, our three core LLMs. So there's the General Masters of Law, the Maritime Law, and the International Commercial and Corporate Law. But obviously you have an interest in maritime law, so I'm moving straight on to the LLM and maritime law. Now we will be offering all the core modules which one would expect in a maritime law program. So you will be taught on marine insurance, admiralty, carriage of goods by sea, international sale of goods, but there will be also other classes on international litigation, arbitration, ship finance, and so on. And in addition, if you wanted to, you could also pick a couple of modules instead. Actually, it's not in addition. So if there was one of the modules from another degree which you were really interested in, you could swap it for one of those modules which we list under the maritime program. Now, when it comes to the an important point which I almost forgot to mention is that throughout the year, the Institute of Maritime Law organizes guest lectures. Lots of them are by practitioners. They are very popular. It gives you a very practice-focused insight on maritime law practice, and our students very much appreciate it. And it really actually goes to show the long-standing tradition Southampton Law School has with the maritime law world, and lots of the practitioners will actually be alumni from the law school. On dissertation topics, you might be asking yourself, well, what should I be writing about? Will I be told the topic? Now, no, we don't tell you what you should be writing about. We do exercise some oversight, but really the choice is yours. Now, the choice is yours. It must be a topic on maritime law. We encourage you to pick something you're interested and passionate about. We are also encouraging you to do something that is current. And so I've given here on the handout, on the PowerPoint, there are a couple of examples of dissertations I've actually recently supervised. So there are quite a few students have shown an interest in autonomous shipping. So obviously it's a very interesting, very current topic, or blockchain technology and how that might impact on the shipping sector. This is not to say that you don't necessarily have to go for something current as technological. There might be legal developments. And I mean, Alexandros has just given us a very good example of, you know, the impact on the pandemic on maritime law, and how it might resurrect some of the older legal principles and traditions. I've just listed the international commercial and corporate law here on the handout. It's just to give you an idea of some of the other modules from which you can potentially pick if you were interested. Yeah, so there would be corporate governance or business finance or the law of the WTO. Now, a lot of these modules would actually have also direct implications for maritime lawyers, and there might be a particular reason why you are interested in that. Conscious of the time, I'm moving on quickly. What other things the Southampton Law School's got to offer? We are, as I said, we take pride in our research, and we have a number of very active research centers, and we are trying to create a sort of research community that is inclusive of our students and in particular of our postgraduate students. So from your point of view, the Institute of Maritime Law would be the first sort of port of call. We also have very strong links with the legal profession. As I said before, you will be given the opportunity to listen to talks from practitioners, in addition to our recruitment fair and other employment events to which you are invited and encouraged to go. I think perhaps from this slide, the most important thing is perhaps the first point, that we're also offering what's called the Processional Program. It runs in the summer and it's English for law. It's for those of you for whom English is not your first language and you're a little bit concerned about studying in English. At Southampton, you could consider participating in the summer program designed to improve your English, in particular your legal English. Otherwise, I'm moving straight on to the next slide. There are a couple of statements from our alumni, and many of which simply confirm what I have already said. This is of no further interest to you. Living in Southampton is, of course, of interest to you. Southampton, I don't know whether you've been here, but Southampton is a port city, so it's actually, there's a lot of international trade going on. We have huge cruise ships and container ships coming in and out of Southampton all the time. But there is also a very lively city with all the opportunities a big city offers. So it's a great place to study, and it's warm and sunny most of the time, which of course is only a minor point. Last but not least, residences. You can choose between private residences and residences or accommodation offered by the university. Probably, if you're new and if you want to make quick and easy contact with other students, going for university accommodation is probably the easiest way to make friends and to meet other people. And so I probably would encourage that, but you get different standards from self-catering to partly catered and so on. So this really depends on your preferences, which really brings me to the end of my quick overview of what we have to offer. If you have of course the opportunity to ask questions now, but you can also, if you think of something else later on, do feel free to either pop into the personal catch-up, which will happen, I believe, next week, or send me an email. But otherwise, I think we are ready for the Q&A session. Hello. Hi, Emily. Hi, Song.
Hi, Uta and Song. I'm just wondering if Alexandros is joining us again. I believe he should be.
Alexander, yes.
Okay, So we are now assembled. You have already met Uta and Alexandros. So this is your opportunity now to meet Song, who, as I said earlier, is joining us from the Faculty International Office, which she directs. But Song will be able to answer any particular general questions about the wider university and studying in Southampton that you might have that go beyond our knowledge, potentially. So this is just intended, as Professor Cole has just said, there will be an opportunity that if you have further questions, you can either have a personal catch-up or one-to-one chat with Professor Cole if you have questions about the programme, or you can, of course, contact her by email after the event. All right, but if you have any questions just now, we would welcome them. We have had one question in from Leisha, I think, which was, what do we cover in the Introduction to the Common Law course? And my thinking is that Uta would be the best person to answer that question.
I think it's, I'm not involved in this course, but it's designed to, as what is covered is common law methodology. So the idea of binding precedents and judge-made law. So there is great emphasis on that. There would be stuff on statutory interpretation, and there would be a general introduction as well. Very short, very brief, because you will get more on that later, on international law. So the emphasis will be on common law methodology, and that broadly captures the idea of judge-made law, how to read cases. So reading cases is really essential for doing our course, and how to find the law in the cases. Yeah, which for students from civil law traditions is somewhat daunting and, yeah, quite new, but ultimately not that difficult. It just takes practice, and you will be given a lot of practice in that.
Okay, thank you very much, Uta. We have another question which concerns the possibilities for interaction with legal practitioners during the programme. And I think, as Uta has already highlighted, we have regular talks that are given by legal practitioners. But in addition, there are law prizes which are awarded by individual legal firms, which give students in some instances not only money, hard cash, always good, but also on occasion, mostly generally, they will also offer the opportunity to undertake a work placement. And I don't know if Alexandros or Uta would like to give any detail about examples of those, or any further detail about the talks, perhaps. Alexandros?
Thank you, Emily, for this. Indeed, we do have the very known nowadays, and one of the most important features to the LLM program, which is the Wednesdays Practitioner Seminar. And as the name suggests, we do have every Wednesday prominent practitioners in maritime law to visit us from the city of London, and in many times also from abroad, to give a more specialized or a technical insight to maritime law issues that we have been covering from an academic perspective. In that context, the students are given the opportunity to interact with these practitioners, and we do encourage the development of the network through this kind of interaction, but also through law fairs, which also cover specialized maritime the maritime market around the year. On the top of that, we do have also a number of dedicated to maritime law prizes that are being sponsored by important international maritime law firms, and also the maritime industry, for example, the protection and indemnity clubs. And finally, I would like to pick up the part of the question regarding internships. We do have in the Institute the opportunity to award annually an internship to a student who help us to prepare the Maritime Law short course, which is one of the global brand names for the Institute, which has been offered in August each year, and the internship also help us to support the preparation of the Donald Tomei annual lecture that takes place every year in London. So we do offer the possibility of internships, but it's not something, I'm afraid, that can be easily gained, because the the Institute of Maritime Law, it's a practitioners-minded and market-facing entity, which undertakes a lot of consultancy activity. But nevertheless, we do welcome students, especially in the library, which is one of the very few specialized libraries in maritime law that exist in academia. And we do offer, as I said, a limited number of internship opportunities to excellent students.
Okay, thank you very much, Alexandros. I see that we have another question, which I suspect is at the top of many of your minds at this point, which is whether the impact of the pandemic and international border restrictions means that we will be doing online teaching delivery in the first semester or maybe longer. And I think that what really is clear to say, and it will be evident, that we are obviously planning to be in a position to deliver online as necessary in the next academic year. Clearly, we have contingency plans in place, but obviously we won't be taking final decisions on that until events unfold and we're closer to the time. But equally, clearly what we do want is to get students back to campus and back in face-to-face contact as soon as is safe and practically possible. Obviously, this is complicated and there are difficulties around, for instance, visas, and there are timescales that need to be engaged with and addressed in order to be able to do this. So clearly we're planning for both, but at this stage, I think it's too early to say. I don't know whether Song or Uta want to add anything further on that, if they have more up-to-date information than I do.
Yes, all I can say is really confirm, Emily, what you've said, and said that the university is working on a plan. So no final decision has been made. I think the expectation is that some teaching will be online, but there's also, I think they're also working very hard on facilitating on-campus teaching, perhaps in an altered form. So it is actually at this point very unlikely that we will have traditional lectures, but we might go, as many universities are planning to go, for smaller group teaching, which actually, as a learning experience, I would think it's more intense, it's more valuable for students. So I mean, I am hopeful that we will be able to offer a mix of online teaching and on-campus teaching, but at this stage, no final decision has been made.
Yes.
I just want to add that, yes, I just want to add that actually our staff has been producing online teaching material for this semester after Easter, and the university is focusing on producing high quality online teaching experience for the students to ensure that you have the same level of learning experience online if we have to go down that route next semester as well.
Okay, all right, thank you very much, Song and Uta, for that. So the answer is we're preparing for all eventualities, but we are clearly keen to have students back on campus for as much face-to-face small group teaching as will be safe and practical as soon as possible. All right, moving on, I can see another question which concerns where students work following graduation. What kind of career destinations our graduates from the LLM in Maritime Law and top programs more generally have? So I don't know who would like to take this one. Alexandros, perhaps, or Uta?
Alexandros.
Yes. Let me start by saying that LLM Maritime Law in Southampton is one of the oldest specialisms in maritime law that have been offered in Europe. In that sense, we have been blessed with students that attended the program early on in 80s, which now they run their own maritime law practices. Either they have joined as senior partners the big international shipping firms, and that give us the immediacy with the market. So yes, a Southampton law graduate from maritime law can work in many areas of shipping. It's a quite versatile market. It does not necessarily include only or confine to the practice in courts of maritime law, but in the wider spectrum, but covers the wider spectrum of shipping. So it might be a maritime law office proper, which deals with litigation. It might be a marine insurance firm. It might be a casualty firm. It might be a protection and indemnity club. It can be most of the times as well as a general maritime law practitioner that works for the ship owners, which we call the in-house maritime lawyer, which represents at first level the ship owners' interest. So the maritime employment market is quite versatile and quite big. And all of us, at least the lawyers, know that a lawyer can do almost any job if needed.
Okay, thank you very much, Alexandros. Song, did you want to come in there?
Yeah, I just want to highlight for international students that for the new post-study work rule, you will be eligible for 2 years PSW. This is the new policy in UK. As an international student, during your study, you can work up to 20 hours per week. There's no cap to your income, but there is this cap to and a limit to the hours you can work. But from the moment that you submit your dissertation, you will have, you will be eligible for 2 years of the PSW.
Okay, thank you very much, Song. There is one final question that I can see that's come in, which is about suggestions, again from Leash, which is again about suggestions for pre-reading. And I think there are resources which give some indications of pre-reading, but that might be a question. I don't know whether Alexandros would like to give a quick answer or whether this is a question that would be best followed up either in one-to-one chat or through email, because obviously if we give a list of books, it's hard to note that all down and take it, but I think the information is possibly on the web to some extent. Alexandros.
Yes, indeed, and so far we have already received similar requests. In order to be more thorough, I am sure Professor Cole will be able to respond, or if that relates to maritime elements within the introductory course on common law, myself can provide an indicative list that can be used in preparation for that.
Okay, thank you very much, Alexandros. I haven't seen any further questions coming in. I'm sorry if I've missed anything. If there are any further questions, I can only reiterate, please do either avail yourself of the opportunity for a one-to-one conversation with Professor Cole or contact her in the first instance via email. And other than that, I would just like to thank Song for joining us, Alexandros for joining us, for helping with the questions and answers, but also for an incredibly interesting lecture and hopefully a useful indication of the kind of online teaching we might give, of the kind of teaching and lecturing that we offer as part of the programme, and in particular the way in which the subject matter, reflecting what Professor Cole said about the fact that we are quite research driven here, Alexandros' presentation should really have indicated that we continuously place the work we're doing, place the law in the contemporary context in order to ensure that it is relevant and up to date, but also that our students get a sense and understanding and develop their own ideas about the application and how law can be applied in order to deal with new kinds of situations and crises that come along. And I think Alexandros' presentation would really have given you a sense of that, I hope. Obviously, I'd like to thank Professor Cole for a very informative talk on the programme, and hopefully she will have answered some questions that you might have had about the programme outstanding, and also given you an indication that she is very approachable should you have any further questions that arise after the fact that you would like to ask her. Other than that, I would just like to thank you for joining us today and to look forward to hopefully welcoming you to Southampton and certainly to Southampton Law School in the coming academic year. All right, thank you. Bye.
Thank you.
Bye.
Bye-bye.
Good luck with your study.
Bye.
Bye-bye.